Okay, I think we'll make a start then. Good afternoon and welcome to today's session on defending age assessment. This is a guide which is aimed at, but not exclusively for, local authorities. I will be co-presenting the webinar with my good friend and colleague, Dr. Russell Wilcox. My name, for those who don't know me, is Anirudh, and I practice in public law, including court of protection, inquests, and judicial review. And I'm also a member of the Attorney General's panel on the C panel. One of the areas which I've seen an increased growth in is acting for local authorities in age assessments, both in the pre-action stage and once claims have been issued. Now, these assessments are of the utmost significance for local authorities and accompanied asylum seekers in complying with their statutory obligations. Indeed, if an accompanied asylum seeker is a child, they are entitled to age-appropriate education, healthcare, and accommodation. And it is therefore critical that those employed by local authorities undertake a thorough, informed, and fair assessment of individuals that they consider to be at the margins of adulthood. This webinar will explore the facts that local authorities ought to consider when undertaking an assessment, common grounds of challenge, relevant procedure, and the Home Office's National Assessment NAB procedure. So, looking at the statutory framework, unsurprisingly, a child is defined as a person under the age of 18 years, pursuant to Section 105 of the Children Act. And importantly, as I'm sure most of you will recognise, a child's age is an objective fact. It's not a matter of opinion or an administrative decision. The leading case in this regard is Crown on the application of A and the London Borough of Croydon, in which the Supreme Court decided that the correct approach to be adopted in determining a young person's age was a matter of fact. Lady Hale held that the question of whether the person is a child is a question with a right and wrong answer, and the term child is undoubtedly defined in wholly objective terms. Therefore, age is a matter of jurisdictional fact, and it's established that there's no margin of discretion enjoyed by the local authority on this issue. I mentioned earlier that if an accompanied asylum seeker is a child, they are entitled to age-appropriate education, healthcare, and accommodation. As I'm sure those of you will know, Section 17 of the Children Act imposes a general duty to make provision of services for children in need. This includes the general duty to safeguard and promote the welfare of children within the area who are in need. By Section 20 of the same Act, a local authority is duty-bound to provide accommodation for a child until they are 18, and Section 11 of the Children Act 2004 obliges a local authority to ensure that its functions are discharged, having regard to the need to safeguard and promote the welfare of children. So, looking at this procedure of such claims, any claim challenging an age assessment must be pleaded by way of judicial review in the Administrative Division of the High Court. In order to obtain permission, the claimant must prove a factual case which, taken at its highest, could properly succeed at a contested factual hearing. Now, unless that claim is filtered out at the permission stage, the claim will generally be transferred to the Upper Tribunal as the specialist judicial review forum for a factual determination, afresh on all available evidence. Standalone conventional judicial review grounds, i.e. those that would apply to a classic secondary supervisory review of inclusion involving judgment and appreciation, are in fact subsumed in the objective age assessment. Such standalone convention grounds, of course, remain relevant, however, in determining what weight to attach to a local authority's decision. And a critical point is that it's important not to forget that age assessment claims are still judicial review matters and are therefore subject to the strictures of judicial review procedures. This includes a limitation period of 3 months and a duty of candour for all parties. But more of this will be dealt with by Russell. The grounding case for all local authorities is crowned on the application of B and Merton LBC, henceforth known as the Merton Principles. Now, these principles were recently summarised in the case of AB and Kent County Council, which I've set out in the following slides. I won't go through all of them in detail. You can read them at your leisure. But what I would say is that these principles are categorized into the following categories: the purpose of the assessment, burden of proof and the benefit of doubt, physical appearance, conduct, the preliminary decision, and the decision and reasons. But I would stress, however, in the Crown on the application of Ham and Brent London Borough Council, Mr. Justice Swift made it clear that these principles are not a checklist. They are not requirements of fairness. Rather, what they constitute are elements of good practice and general guidance. So I would recommend reading this list and thinking about it when considering whether the age assessment is fair. But in addition to this, I would also recommend reading the Age Assessment Guidance, which was published by the Association of Directors of Children's Services and was updated in 2023. Now, occasionally you may come across something in the literature which is known as a short form age assessment. Now, this often means different things to different people, but it was once thought that there was some form of age assessment where the requirements of fairness were less stringent than in Merton, the principles which I've just outlined. But in Ham, Mr. Justice Swift indicated that any such distinction, if it ever existed, is not legally relevant. All cases must start with the principles outlined in Merton of a reasonable investigation and a fair process. But what fairness demands will depend on the circumstances of the case. Now, one of the points that's often raised by claimant solicitors in relation to the adequacy of an age assessment carried out by a social worker of an unaccompanied asylum seeker is whether they've taken or given undue reliance to the claimant's physical appearance when determining age. And at first blush, this might seem like a good point, because physical appearance is notoriously unreliable. If one considers an unaccompanied asylum seeker who has gone through war and has made their war trauma and has made the arduous journey to the United Kingdom, then a tribunal is likely to take the view that their physical appearance may not be maybe or what's termed a fragile material in determining a person's age. It is notoriously unreliable. But what this doesn't mean is that it's completely irrelevant or it's not a good starting point for assessing a person's age. And a useful case in this I found is Crown on the application of GB and Leeds City Council. Now, just setting out the facts, this was a decision on permission to appeal, which concerned an Iranian national whose case was referred to the defendant local authority. There was a brief inquiry in which it was suggested that the claimant was likely over the age of 25, but after a full age assessment process took place, it was concluded that his age was actually 20, and that decision was challenged. And one of the issues was whether the claimant the defendant had taken undue reliance or placed undue weight on the physical appearance of the claimant. In his judgment, Mr. Justice Fordham, first of all, cited this passage from Merton, which I'll read. You can read at your leisure. But essentially, he says that in a case where the applicant does not produce any reliable documentary evidence, the determination of his age can include his physical appearance. And it's a common argument that there's been an over-reliance by social workers on physical appearance. And again, one can see, for example, you have a short meeting with a stranger, and that these factors can be fragile. And the fact that, for example, that especially in the earlier age assessments, it can be undermined by the use of COVID pandemic and the use of masks. But That case was actually rejected in GB. And what it said was that the approach taken by the social workers in that case properly reflected Merton and the 2015 guidance because it indicated proper but not exclusive reliance on physical appearance and demeanor. And it's perfectly legitimate for physical appearance to be a factor or an initial view, as long as it's not the sole basis upon which you make your decision, or as long as it's not taken undue, given undue weight. And that can really be, it's very important in that regard to make sure that the decision that's created doesn't place undue weight on physical appearance. And a good point that I've seen is obviously if the age assessment document makes it clear that the actual document which the social workers fill in makes it clear that it's just a starting point, then that will at least fortify the court, a judicial review court, or the upper tribunal's decision that the social workers didn't place undue weight on that matter. Another point you often see is you get evidence from professionals who have worked alongside the claimant. This can include teachers, family members, or other professionals who have worked alongside him, who have educated him. And a common argument that's made is that professionals who've worked with the claimant over a substantive period of time are more reliable than those who've worked in the confines of the age assessment. And again, one can see the value in that judgment, in that argument, that someone who's a teacher, for example, that's worked with him with the person for a substantial period of time and has a more thorough view of the maturity of that person will carry some weight in determining whether the person is a child or not. And this argument was reflected in Crown on the application of AM and Solihull Metropolitan Borough Council, in which the Upper Tribunal indicated that professionals who could point to consistent attitudes and a number of supporting incidents over a considerable period of time, that argument is likely to carry weight. It is one approach. The difficulty I have with that, and I accept it's often context specific, is that the evidence of a teacher or a charity professional can be of limited value because they haven't been trained in the assessment of age, or in Merton compliant principles. And indeed, in the case of currently the application of F and Manchester City Council, the High Court was not rather than being skeptical, was skeptical at the value about the use of evidence for other professionals. Now, in this case, the claimant had relied on evidence from a support worker and a missionary, and Mr. Justice Julian Knowles accepted that, but he also identified that context is everything. Evidence can be of assistance, but it all depends on the facts. What is important is what he says in this passage, that the defendant took that into account, concluded, but it didn't take that much matters much forward, and they were entitled to take that view. Now, of course, it's important to recognize that in F, they were dealing with what's known as dealing with an irrationality challenge rather than one based on a jurisdictional fact. But it's still a useful passage to identify the level of discretion taken by the local authority. Further, in my experience, it's not uncommon for further evidence to emerge after the age assessment, which seeks to challenge that assessment. The test for fresh evidence on the basis of new information is whether a significantly different conclusion might be reached. This was described by Leanne Mulcahy KC, sitting as a deputy High Court judge, as a higher test and one that involves consideration of the degree to which material might impact on the existing age assessment. And this, of course, is higher than simply whether the new evidence has a bearing on the existing material. So, in the case which I've cited there, Crown on the application of G and the London Borough of Greenwich, the fresh evidence deduced was a Christian identity card, a report from an expert on the education systems in Angola, and evidence from those who had dealings with the claimant. And the upshot of this judgment was that the defendant was entitled to find that such information did not justify a reassessment of G's age. It certainly supported the claimant's timeline of events, but in circumstances when the original assessment of age had been based primarily on a timeline drawn from what the claimant had himself said, and where his credibility had been found to be lacking in so many respects, the further information that he needed to put forward to justify a reassessment needed to be quite compelling, and in this case, it did not meet that standard. And another issue that often arises in age assessment of claims is the production of documentary evidence after the age assessment. So, the classic example is after, say, your letter of response, the claimant finds an identity card or birth certificate, sends it over, and the defendant is asked whether it wishes to actually continue challenging that whether it still considers that the claimant is a child. Now, sometimes, and it's an important distinction to draw here, there concerns of fraud. And the critical point here is that a distinction ought to be drawn between cases in which it's alleged that the document itself is fraudulent and where it is alleged that the information upon which the document is based upon is erroneous. And that's a really fundamental distinction for the following reasons. I'll give you an example. Let's say you have a birth certificate and you're fairly sure that it's a fabrication. As a local authority, lawyer, or solicitor, the proper approach is set out in the ACDS, and that's to send those documents to the Home Office to establish the reliability of the documentation. And the Home Office can also refer that to internal document fraud experts. And the reason why that's critical is that while you may suspect that it's a fraud, that the certificate is fabricated, ultimately, as a legal expert, you're not an expert in the reliability or the the provenance of birth certificates in a foreign country. But by contrast, let's take a different situation. Let's say you have an identity card from the claimant. Now, it doesn't appear that the identity card itself is a fabrication. It looks like something that was a genuine identity card, but the information within it doesn't seem to be correct. So, for example, I'm just taking off the line. It says, for example, that the claimant's father, is a teacher, whereas in fact, in previous evidence, it said that the claimant said that his father was a farmer, for example. In that case, it's not necessary that you have to go to the Home Office. And this distinction was actually really well drawn out in the judgment of a case I mentioned earlier, Crown on the application of F and Manchester City Council. Now, in this case, the claimant challenged the local authority's age assessment after providing fresh evidence in the form of a court document from Guinea, purporting to show that he was 17 and not 20 as alleged. And Mr. Justice Julian Knowles drew an important distinction in this matter. And he stated that because the defendant does not take issue with the genuineness of the document, but disputes the reliability of the evidence on which it is issued and who exactly it's obtained it, Mr. Swirsky, the counsel for the defendant, was right to say that asking the Home Office to verify it would have achieved little. I pressed Miss Benfield, that's counsel for the claimant, whether the Home Office would have been able, that should say able, not table, sorry, to delve into its evidential foundations as part of the verification process, but she was unable to say that it would. And that's a really useful passage which draws out the distinction between those different types of evidence. The final point which I want to deal with before I go on to Russell is a point that's often raised in letters for action. It's the benefit of the doubt. Now, this has been said by a lot of letters of claim, but AB and Kent County Council, what it says, sets out what it actually means. It is nothing more than an acknowledgement that an age assessment cannot be concluded with 100% accuracy in the absence of definitive documentary evidence, and in the case of unaccompanied asylum-seeking children who may also have been traumatized and don't have any other evidence. The proper application is that where, having considered the evidence and the decision concludes that there is doubt as to whether the individual is over 18 or not, then in those circumstances, the decision maker should conclude the applicant is under 18. It does not mean, as some people suggest, that in every case you should, where there's any sort of ambiguity, you should automatically find in favor of the claimant. It's where the assessor finds that there's doubt, they're not sure which way to go for because there isn't any definitive documentary evidence, and in those circumstances, you give the applicant the benefit of the doubt, and you find that that they're a child, and that's perfectly legitimate in and of itself. But it's often that principle is set out in Merton. It's often extrapolated to go way beyond what Merton suggested. So that concludes my portion of the webinar. I'm now going to hand over to Russell.
Thank you very much, Anirudh. And Anirudh is going to assist me with moving through the slides, so every so often I'll nod in his direction. So in addition to local authority age assessments are also regularly undertaken by the Home Office itself. And it is important for local authorities to understand those Home Office age assessments and the processes surrounding them as part of the wider age assessment landscape and how that landscape is developing, and it is developing. Home Office age assessments have tended to serve an importantly different purpose from those of local authorities. They apply the same legal principles that have been discussed by Anirudh, but they are concerned with the discharge of different statutory responsibilities. They are, of course, like local authority age assessments, concerned to ensure age-appropriate treatment. But they are particularly concerned with determining whether or not detention restrictions can properly be applied, normally under Schedule 2 of the Immigration Act 1971, and then more generally with compliance under Section 55 of the Borders, Citizenship and Immigration Act 2009. This is specifically reflected in Home Office policy, which is said to aim at guarding against the detention of children. And of course, serious consequences can follow from incorrectly assessing a child as an adult in the immigration context over and above those which flow from the incorrect assessment in the context of local authority responsibilities. In the Supreme Court case of BF Eritrea and the Secretary of State for the Home Department 2021, it was recognised, reflecting the earlier decision in Crown on the application of A, that the question of whether a person is a child is a matter of precedent fact. It is not a question of reasonable assessment by immigration officers. And of course, this means, as Anirudh has already mentioned, that a particular form of judicial review is applicable, namely a form of judicial review which allows for fact-finding hearings, which are relatively rare. The other common category that I can think of is in the case of nationality claims, but generally speaking, as I'm sure everybody on this webinar knows, judicial review is not normally an arena for fact-finding decisions. This is a particular type or gives rise to a particular type of judicial review proceedings. If we could move on to the next slide. The Home Office age assessment process is one which takes place at the initial stage when immigration officers, or it's designed to take place at the initial stage when immigration officers first encounter immigrants. And it is undertaken by two Home Office staff, one of whom must be a chief immigration officer or higher executive officer grading. The assessment will sometimes be based upon physical appearance in part and demeanour, where these very strongly suggest that the person is significantly over 18. But otherwise, they will have to consider a range of evidence in the same way that local authority age assessors would have to consider a range of evidence. A Home Office assessment, age assessment, is distinct from a local authority age assessment in, as I've said, in its purpose, but also to some extent in its procedure. And it is therefore not binding on local authorities. So it is not sufficient for a local authority simply without more to adopt a Home Office assessment. A local authority must make its own independent determination. To this relatively straightforward distinction between the two forms of age assessment, local authority age assessments and Home Office age assessment, must be added a number of recent developments which point towards potentially significant procedural, evidential and legal changes in the near to medium term future. One such development, which provides a little bit of context to these changes, was the establishment in the summer of 2020, next slide please, of the Kent Intake Unit in response to an unprecedented number of arrivals of asylum seekers crossing the Channel in small boats. This obviously placed significant pressure on Kent County Council's children's services, and this eventually led them to a decision to stop accepting newly arrived unaccompanied asylum-seeking children. In response, the Home Office contracted social workers to support immigration officers through this newly established unit, and how that unit operated was described in the case of the Crown on the application of MA and the Secretary of State for the Home Office 2022 case. The Kent Intake Unit had its own set of or its own guidance, which operated alongside the existing age assessment, assessing age policy rather. And in the case of Crown on the application of MA, the Court of Appeal held that that guidance was lawful. It did so on the basis that it directed compliance with the Merton principles and relative case law. So there's clearly a significant degree of overlap, and the principles outlined by Anirudh, unsurprisingly, are imported into this context. A more significant development, however, it came with the passage of the Nationality and Borders Act 2022, otherwise known as NABA. And this introduced a number of developments in the area of age assessment, developments which have already been implemented and those which have yet to be implemented. One that has or one innovation that has been technically brought into effect is the establishment of the National Age Assessment Board, rather unattractively referred to as NARB. And we go to the next slide. NARB was established as part of the Home Office, although in recent cases, the extent to which it can be assimilated to the Home Office has been raised as an issue, if not actually adjudicated upon, which can potentially or could potentially raise questions as to which the correct body is for review. But that yet is still an undetermined matter. It consists primarily of social workers who conduct age assessments following referrals, both from local authorities and from the Home Office itself. You'll see that by section 49 of NABA, an age-disputed person is defined by a person who requires leave to enter or remain in the United Kingdom in relation to whom a local authority or the Home Office have insufficient evidence to be sure of their age. This statutory framework is designed to provide greater consistency in age assessment decisions. But as I've said, other than NARB, there are a number of items of the new machinery which still have to be implemented. Turning to the referral process itself, if we could go on to the next slide, Anirudh. Under section 50, subsection 3 of NABA, a local authority has three options when they need to know the age of an age-disputed person. Firstly, they can refer the individual to NAB for a statutory age assessment. Secondly, they can conduct their own assessment and then inform the Home Office of the result. Thirdly, they can accept the claimed age of the individual without an assessment and again inform the Home Office. Significantly then, so it's important to recognise that NAB is a resource which the local authority or local authorities can make use of, but it is not something that they must make use of. However, when NAB accepts a referral and carries out an age assessment, that age assessment will be binding both on the local authority and on the Home Office. And this is provided for by section 50, subsection 7 of NABA. Likewise, the Home Office can also use NAB as a resource and can make its own referral by section 51, subsection 1 of NABA. And that describes the ability of the Home Office to make such a referral for the purposes of deciding whether or how the Secretary of State or an immigration officer should exercise any immigration functions in relation to the person, rather uncontroversially. Importantly, when such a referral is made, that will be binding on the Home Office, but it will not be binding on the local authority. So there's a subtle difference between the two forms or the age assessments, depending upon by NAB, depending upon which body has referred in the first place. Now, there hasn't been a great deal of case law, but as I was preparing for this webinar, Anirudh drew my attention to a case which I was aware had been making its way through the Upper Tribunal, but was only handed down 2 days ago on the 2nd of December. If we go on to the next slide, Anirudh. And that is the Upper Tribunal case of R on the application of SS and Secretary of State for the Home Department. This is one of the first substantive challenges to a NARB age assessment following a local authority referral. It concerns a young Afghan asylum seeker, SS, who originally arrived in the United Kingdom in October 2022, initially stating that he had been born in 2005. In January 2023, he was moved to adult accommodation after being deemed, on the basis of his initial claimed age, 18. But later on, he obtained an Afghan tazkira, which is a form of identity document, showing that his actual birth year was 2007, which would make him 16. A referral was made, I think it was by Croydon County Council, and the NARB conducted an age assessment between April and June 2024, concluding that SS was 19 years of age. This assessment was based upon a number of factors, significantly a whole host of what the NARB assessed as inconsistencies in SS's various statements. In addition to the fact that he had said during the assessment interviews, I don't know 150 times, and I can't remember 49 times. As a result, of course, of the NARB determination, his support and accommodation were conclusively terminated. SS then inevitably challenged this assessment, and in doing so provided psychological report and medical evidence with 3 experts confirming that he had suffered, or that he did suffer, from untreated epilepsy, PTSD, and cognitive issues. Professionals who worked with him also testified that he had appeared to be a child and behaved as a child would. The Upper Tribunal rejected NARB's assessment, finding that SS's demeanour and lack of memory were attributable to his untreated medical conditions, not to deliberate evasiveness on his part. The tribunal accepted SS's account of not really realising his recorded age was incorrect. And ultimately, the tribunal, as it was tasked to do, determined on the balance of probability that SS was born on the 1st of January 2007 and was therefore a child at the time of the NARB assessment. The NARB's assessment was therefore quashed. So that's a useful recent case showing the interaction between a local authority, NARB, and the role where there is a dispute of the Upper Tribunal. Another potentially significant development introduced by NABA is the use of scientific methods of age assessments, which is provided for now under Section 52 of NABA, which allows for the laying of regulations to specify scientific methods which can be employed for that purpose. Despite significant opposition from the House of Lords, regulations were in fact laid, and passed in January 2024, the immigration age assessment regulations of that year. And these permitted, at least in theory, the use of X-rays and MRI for the purpose of age assessment. Sorry, we should move on to the next slide. Thank you. Now, this is a highly controversial approach. Firstly, there are significant accuracy concerns, and it's not clear that there is much scientific evidence to justify the accuracy of using these techniques. Secondly, there are, of course, ethical concerns, because X-raying an individual to identify what their correct age is not using a potentially harmful medical procedure for therapeutic purposes, but for non-therapeutic purposes. And then, of course, there are, linking into the first concern, margin of error questions. It is clear, though, that within the legislation, there was a desire to make this a potentially available route in the future. I am not aware that it has been relied upon, for all of the reasons that I've articulated, much since the regulations have been passed, but a marker has clearly been placed down so that should the scientific evidence or the scientific techniques become more accurate, then that is a resource that could be utilised. I would not currently suggest that it would, to those who are assessing or attempting to make age assessments, that it would be something that reliance should be placed upon. Next slide, please, Anirudh. The final, perhaps in due course most significant innovation introduced by or contemplated by NABA is the provision of a right of appeal to the first tier tribunal against age assessments conducted under the Act. And that is provided for in section 54 of NABA, which provision has not yet, as far as I understand, been brought into force. When it is implemented, of course, then the tribunal will be able to determine, or will be tasked with determining, appeals on the balance of probabilities, and it will be required to assign a date of birth to the person in question. The tribunal will also, of course, be able to consider new evidence not available at the time of the original assessment. Standing back, one can understand why a right of appeal has been introduced in light of the fact that the current way of challenging age assessment decisions is by virtue of a modified form of judicial review, which is obviously more likely to be more expensive than a hearing before the first tier tribunal, and which is atypical in terms of the type of cases that are dealt with by the administrative court. The section 54 appeal rights then, when they are brought in, if they are brought in, will eventually become the sole mechanism for challenging age assessments. They will replace the current judicial review route. The tribunal's decision, of course, will be binding on both Home Office and both the Home Office and the local authority, and it's contemplated that it will provide a more definitive resolution of age disputes thereby. For now, however, if we can go on to the next slide, as judicial review remains the only process for challenging age assessments in England. The landmark case of the Crown on the application of Croydon London Borough Council 2009, the Supreme Court case that Anirudh has already referred you to, established that it is for the court itself to determine the age of the individual. That, of course, is a close consequence, or flows from close consequence, of its decision that the age of an individual is a matter of precedent fact, not one that falls within the reasonable assessment or the margin of reasonable assessment, or Wednesbury reasonableness, the margin of reasonable assessment, which is most commonly applied in judicial review claims. While a local authority's assessment is relevant, therefore, when a matter comes before the administrative court, it is not determinative, and the court will consider all available evidence to reach its own conclusion on the individual's age. This approach has created some conceptual difficulties, and this was noted in the case of the Crown on the application of SB and Kensington and Chelsea Royal London Borough Council 2023. And it notes that, of course, the decision in A and Croydon has reduced the importance of procedural challenges in a substantive judicial review age assessment. Procedural challenges, as the name suggests, if we can go on to the next slide, focus on issues such as a failure to follow the Merton guidelines, the provision of inadequate reasons, and procedural unfairness in how the assessment was conducted. Factual challenges, as the name suggests, ask the court to determine the individual's age itself based on all of the evidence, including fresh evidence, available at the time of the hearing. The Court of Appeal in the Crown on the application of SB observed, in cases like these, the parties and the court should consider whether the overriding objective is best furthered by hiving off a procedural challenge from a decision on the merits. Focusing, therefore, directly on the factual question of an individual's age is likely to be more efficient than addressing procedural issues that ultimately might become irrelevant once the court makes its own decision. That does not mean, however, that procedural issues are not important. And of course, the court itself is going to consider the initial age assessment, and it will take into account the assessment, which after all is made normally by specialist social workers. If there has been a procedural deficiency in their consideration, that is going to mean that the court is less likely in coming to its own factual determination to place a sort of secondary reliance upon the initial age assessment. So it is still, procedural issues are still important, but they don't have the central importance that they otherwise would have in a normal Wednesbury reasonableness judicial review. Moving on then to the next slide, what are the types of evidence that tend to be crucial in these sorts of age assessment cases. There are several categories. Firstly, one will nearly always encounter a detailed statement from the individual whose age is in question, explaining how they know their date of birth, because they will be making a claim that their date of birth is younger to that assessed. Whether they've ever held identity documents, details of their family, upbringing, and education. And all of that, of course, goes to the credibility and the reliability of the account of the individual themselves. That will often be a key factor in the court's determination. And in fact, that was, as was seen in the case of SS, the largely determinative factor in that case. Secondly, the court will often be faced with statements from third parties, as Anirudh mentioned, who have interacted with the individual whilst the individual's been in the United Kingdom, explaining why they believe them to be a child. That, depending upon the context, will have greater or lesser weight based upon how long they have had interaction with the child, what their relevant qualification is, how they reason to their conclusions. Thirdly, there will often be documentary evidence of an individual's date of birth, such as a birth certificate or an identity such as the Taktira from Afghanistan. That will potentially raise questions of authenticity as to the document, which may need to be assessed not only by the Home Office, but more often more centrally by a country expert. Or it may raise issues, again, as Anirudh mentioned, of questions concerning its content and the accuracy of its content. Finally, a fourth category of evidence, which is often encountered in these form of challenges, are expert reports from independent social workers based on their knowledge and experience with individuals, often social workers who themselves have experience in assessing an individual. Now, because these challenges occur within the context of judicial review, it is very important from the point of view of a public authority, the local authority in particular, to recognise that there is an onerous duty of candour. Now, judicial review proceedings are subject to the normal, and even though these are a modified form of judicial review proceedings, they are still subject to the 3-month outer normal 3-month outer time limit. But more significant, so that's something to bear in mind. Has the challenge been brought in time? Is there a justification for bringing it out of time? But turning to once a challenge has been sort of brought within that window, it is very important to be conscious of the onerous duty of candour which judicial review proceedings place upon local authorities. And I say this because there has been, in recent years, diminishing judicial tolerance for failures to comply with this duty. I mean, it's particularly been aimed at the Home Office, but the consequences of a number of failures means that the court's tolerance is becoming very, very limited. And that is something that local authorities are going to have to deal with and be mindful of. So it is important that all the evidence that is relevant to proceedings are brought to the attention, or is brought to the attention of the court, and the other party. Moving then to the next slide, a particular challenge in these types of cases arises when an individual turns 18 before an age dispute is resolved. The question has been grappled with in a number of cases as to what the potential remedy in such circumstances can be. It was recognised as early as 2014 by the Court of Appeal in the case of GE Eritrea and the Secretary of State for the Home Department that once an individual has turned 18, even if there has been a dispute as to their age, which is ultimately resolved in their favour, the strict statutory obligations will have fallen away. And so the best that an individual could hope for would be, to use the words of GE Eritrea, would be that the council should treat him as if he was a former relevant child. This, as many of you will know, it is a situation in which the local authority has a discretionary power. And so the best in those circumstances that an individual could hope for is that the local authority exercises its discretionary power in the individual's favour. More recently, in the Crown on the application of HP and Greenwich Royal London Borough Council 2023, it was recognised that depending upon the degree of unfairness, blameworthiness, culpability, or other serious maladministration, this may be what makes a favourable exercise of the local authority's discretionary power the sole justifiable outcome. But the relevant factors to be weighed in the balance there will be whether or not an individual has delayed in his or her challenge, whether interim relief was sought, and the degree to which the initial assessment was flawed. That then brings us on, that second factor, the question of interim relief, brings us on to another, if we can move to the next slide, Anirudh, to another almost inevitable type of preliminary application which is made in these form of proceedings. And that is an application for interim relief so that an individual can start receiving the benefits that they would be entitled to were the age assessment ultimately to go in their favour. And this is a recognition of the time it takes to substantively resolve these types of disputes. In the case of the Crown on the application of AB and the London Borough of Brent 2021, this was the quality of the accommodation provided was emphasised. Accommodation is more than a room with a bed and access to a toilet and shower, the court said. A child in need may have a roof over their head, but still obviously require the provision of accommodation by the local authority. So the emphasis is not just upon a child who, or an individual who disputes their age assessment and maybe a child being deprived of basic accommodation. It is being deprived of the quality of accommodation that a local authority would provide a child and all that goes with it, which is qualitatively different than perhaps the type of accommodation which might be provided to an adult asylum seeker. The case of AB and Kent County Council 2020 reinforced the principle that the benefit of any doubt in these type of cases should always be given to the unaccompanied asylum-seeking child, since it's recognised that age assessment is not a scientific process. Now, of course, that has to be sort of qualified in the way that Anirudh suggested, but with those qualifications, that will be a very significant consideration in a judge's mind when considering the question of an interim relief application. Turning then to the next slide, when the courts consider whether to order interim relief, nearly always interim accommodation, they of course apply the balance of convenience test. And that, as it suggests, and as I'm no doubt sure all of you are aware, involves the weighing of any potential harm to each person if the court grants or refuses the order. Now, in doing so, the court is not, of course, blind to the fact that it is not a zero-sum game. It is not that all the harm, should they refuse an interim application, falls upon the asylum-seeking or the individual asserting that they are a child. It's important, of course, to ensure that children are not treated as adults, but it's also important to ensure that adults are not treated as children. And this is not only a question which concerns resources, more centrally, it concerns issues of safeguarding. This, of course, reflected in the quote there from MA, by the court from MA in the case of MA in Liverpool City Council. The wrongful accommodation of an adult with children by a local authority not only does diverts resources from meeting the ends of children to meeting those of adults, it potentially jeopardises the welfare of looked after children. So an important factor which local authorities almost inevitably will raise in interim relief applications are questions of safeguarding. Now, the courts have, if we can move on to the next slide, Anirudh. The courts, of course, as I've said, are not blind to those concerns, but they have emphasised that if those concerns are to be raised, they must be specific rather than generic. And in particular, you'll see in the case of the Crown on the application of S and Croydon London Borough of Council, this was emphasised, this 2017, it was emphasised, but generic safeguarding concerns will be insufficient to resist an application for an interim relief application for accommodation. Again, all considerations, all the circumstances of the case will be considered when reviewing such an application. And I've highlighted there a case where it was found, this is NCH in Vietnam, Sefton Metropolitan Borough Council 2023, where it was found that the availability of alternative suitable accommodation may, in certain circumstances, defeat an application for interim relief, but that will depend very much on specific the specific facts of an individual case. So that's somewhat of a whistle-stop tour. I'm going to end with the last slide, which is a suggestion, a number of suggested best practice recommendations for local authority age assessments. Firstly, it is important that those assessments are based upon the legal principles and framework. Perhaps this goes without saying, but I'll say it anyway. that we have discussed. Conduct a holistic set of assessments and consider all available evidence. It is risky in the extreme just to consider physical appearance and demeanour, save for the most clear type of cases. Give the benefit of the doubt in borderline cases, recognising the inherent margin of error in age assessment. Ensure procedural fairness by giving individuals an opportunity to address adverse findings and providing appropriate support during the assessment process. That will often involve ensuring that a responsible adult is present to support the individual being assessed, although that is not invariably the rule. Consider cultural and social factors that might affect how a person presents or responds to questions. This can be very tricky. There are different ways in which different cultures can respond to direct questions. That may be something that councils in large metropolitan areas are used to dealing with, or individual staff members of councils are used to dealing with. It can be perhaps much more challenging, or much something which staff members from, shall we say, less ethnically diverse councils are used to dealing with. And it is often not straightforward. Sometimes it might be useful to get some sort of expert input. Next, document the reasoning provided thoroughly, explaining how the different factors have been weighed and address any inconsistencies. Maintain awareness of the margin of error in age assessments and avoid overstating the certainty of conclusions. As I've said, seek appropriate expertise, including cultural knowledge and professional experience with young people from relevant backgrounds. Keep informed of legal developments in this rapidly evolving area. And it is an area, as I've said, which is subject to, or has been subject to, a number of changes and will be subject to a number of changes in the future. And it's interesting that one of the factors which the Upper Tribunal felt it needed to comment on in the recent case of the Crown on the application of SS was that the case law, as has developed since Merton, is still the applicable case law, because the Secretary of State had not exercised its power to implement general regulations for dealing with these type of cases yet. That is a power, another power, which is contained within NABA, but be aware that there may come a time when new legislation comes in, and then although it's likely that the case law that we have discussed will remain highly relevant, it will have to be considered alongside these new pieces of legislation. Finally, remember that there are significant consequences in making an incorrect age assessment, not just for the individual in question, but also potentially reputationally for the local authority, and of course in terms of litigation. So those are my thoughts, and I hope they've been of some use. I think now I've got a little set of resource and contact information at the end, but I'll leave that for you to consider.